Hello, everyone. Welcome to the continuation of the Beverly Hills Bar Association NFT Week. This panel is on structuring and negotiating NFT and blockchain agreements. Before we begin, there's a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in the BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with the certificate. You can also access the written materials for today's program via the download link that will be provided to you in the chat. We'll be continuing our NFT week tomorrow, April 1st at 12:30 p.m. with a program titled Tax Implications of Acquiring, Holding, and Selling NFTs. You can register for this event at the BHBA page, bhba.org. So now on to the program. Very excited to announce today's panelists. We have Kent Marcus at Marcus & Colvin LLP. We have Colton McGee, VP at Business Illegal at BMG, and Joseph Anderson at Manatt, who's a partner in the entertainment section. With that, let's get started. Would like to hear from all three of you. Generally, what are the NFT deals you're seeing, the variety, and what are the most common structures you're seeing?
Well, that's a huge question. I'll start, I guess. I haven't seen the same deal thus far come across my desk. What I'm seeing generally is when a platform or an artist is wanting to use IP within their NFT, and it comes in multiple forms of either A, utilizing that IP within the NFT itself, or B, the NFT is used as a key per se and accessing maybe unreleased music or demos on a digital storage locker box. So it's truly varied in my opinion.
I'll go. Probably most of the deals I'm seeing, it's with a creator working with a particular platform, and the licensing terms, who's responsible for what in terms of the creation and the minting, and then also the administration of the drop, what the fees are, and then just the overall rights that go along with that. That's sort of on the broad sense. There's I think a bunch of subcategories from that general deal. What is the what's the drop, what's the NFT, whether it's artwork, whether there's a musical component to that, whether it's an experience of some sort or a package, and also you get into the fractionalized interest of a particular royalty stream. And then once you get into each door, that's going to open up different types of terms and conditions and agreements that would apply to those specific drops. So that's probably, the broad deal is just the agreement between the creator and the platform. And then you're also getting, I'm seeing bigger exclusive type deals between a larger platform with artists that really go beyond just NFT drops. That would go into getting in metaverse rights and blockchain rights that would expand much more than just an NFT. So those are really interesting. I'm seeing more and more of those as we all see the music and the music industry expanding, or maybe I should say the Web3 world and the blockchain community expanding and getting into music. I'm seeing more of those deals beyond just an NFT drop deal.
And then to add on to those kind of deals, we're seeing kind of the creation of this NFT service economy that's coming up, where people who have the wherewithal to create or strategize out an NFT campaign, whether that means creating the smart contract or just being able to have the right engineer around to create smart contracts. But they're kind of serving, these folks are serving as middlemen or middle folks, I guess the correct way to say it now, where they're fighting the artist and then they're fighting the platform. And so they're doing a lot of different deals with different platforms, a lot of different deals with different artists, and we're helping them create out their sort of company structure and their forms and what they need to worry about when they're signing up a creator when they don't know yet what platform they're going to be going to, or they're setting up a creator for, you know, a large campaign of drops or exclusive access points or, you know, whatnot, as we kind of see the community engagement being built up through artists using NFTs and in the space. And so there's that kind of you've got the platform on one side we're working with, you've got the creators on the other side, then you've got these middle guys in the middle, which is where they belong, who are also now kind of making it a little tricky on the practitioners to figure out what we need to cover in these documents. You know, some years before the big spring of last year, it was crypto art drops. It was kind of easy, right? You had an artist who created a unique piece of art, like a physical piece of art. That physical piece of art was going to get sold based off of some blockchain transaction. That was it. And then as we got where the NFTs and the tokens themselves are now pieces of art, or, you know, pieces of collectible material, if not, you know, fully as an art, you know, it's become very much more about the complication of these things. So we're seeing how they expand too as the world kind of gets a grip of what these NFTs are.
Thank you. So to piggyback off that, the structures we kind of seeing have a lot of analogs to traditional entertainment and IP licensing and sales and general transactions, but there's also a lot of interesting nuances that are kind of unique to NFTs and blockchain agreements in general. I'd like to hear from all three of you what you're kind of seeing as far as analogs, what can we actually translate pretty accurately from the deals we've seen in the past, and what are we looking at differently now that we're talking about metaverse and blockchain and NFTs.
Yeah, we can go in reverse order, and I can start this one off. One of the things that, you know, kind of piggybacking on what I was talking about, this kind of service economy, one of the things we're seeing is the realization, or maybe the misimpression, that these are simple licensing deals. That it's as easy as it was before to, you know, to create and launch an NFT as it was to put a piece of art on a CD or a digital, you know, copy of a piece of music, digital artwork for it. And it is much more complicated because of all the underlying science to it. I think we're seeing a lot of sloppy deals come across our desk from other practitioners who aren't thinking about, you know, the complications or the securities issues or the know your customer issues or all that stuff that matter when you're on the other side and dealing with, you know, a company who's very leveraged or very financed or very, you know, worried and risk averse. And so there's that big difference between, you know, what we're actually selling this on, what the platform is, and what happens next, that I think is a lot more complicated and nuanced than it used to be when, you know, we just kind of thought, okay, well, we license the IP onto this product, the product gets manufactured, distributed, and the first sale doctrine kicks in at a certain point. And now here we are, you know, with secondary sales and being able to track and how great this all is on the ledgers and on the blockchains. But you know, it makes what could have been, you know, what somebody might see as a simple deal a lot more legally complicated. And I'm finding it, you know, and I'm sure Kent is seeing this as well. I don't know how much you're seeing on your side, Colton, but explaining to our clients that these are complicated and different and can't be done in a one-page deal term memo without, you know, a lot of kind of back understandings and things to be flushed out. But I guess it's true with any kind of new frontier, right?
Yeah, absolutely. Go ahead, Kent. You take it next.
I was going to jump a little bit on that. The challenge, you know, while there may be some basic principles in terms of warranties and reps that you would find in all types of different deals, it really becomes more challenging in these deals because it's also such a new technology and a new, I'll call it a distribution platform. Not only are the rights different, but we don't have a lot of history here. So, you know, you try to build warranties and reps to protect your client, whether the client is on the platform side or the creator side, when you're just kind of predicting. And you know, I don't know if we're going to, I know there were some other panels on SEC rules and regulations, but you can try to build all these warranties and reps, but you really, you know, we're swinging in the dark a little bit. You know, we can use our best experiences and history and knowledge and education. But at the end of the day, it's really, cliche to say it's the Wild West, but it makes it fun to be creative in drafting these deals. And I think we're all kind of riding the wave, and drafting as we see fit, depending on the client. But that just creates the added challenge too, that while yes, there's warranties and reps and indemnification, but what are we warranting and what are we representing and what are we indemnifying for?
Yeah, and I think, one of the most common terms I hear in this business is let's not recreate the wheel. Let's not recreate the wheel. Well, as Kent and Joseph have said, I mean, we're having to recreate this wheel. Term sheets that come across are generally they've all been different. You have to be constructive in crafting and drafting to fit and to protect and to give your client all the protections they need. And it's some may think it may be as easy as maybe we take a sync license that we've been using for years and we reconstruct it, but there are additional layers of different topics of protections that you will need for your client. And it's kind of understanding what are those things and how can you best protect your IP and your client.
That's super interesting. I want to get a little more, if you could speak a little more on what specifically in the reps and warranties, or also with audit rights. What are you looking at? What are the ideas that are being thrown around, and what do you like and what are you including in your deals? Also for our audience, in the materials, there's some example reps and warranties for illustration, but I wanted to include as part of the conversation as well.
I think the reps and warranties from my end are, I'm not seeing much of a big difference in them. I mean, if you're talking to an IP holder, right, I want the strong reps and warranties. They own the IP and that no third-party consents are necessary and that they're going to cover everything. The problem is kind of relying on those reps and warranties or relying on the indemnification that follows it. A lot of the people we're working with, it's not like they have significant, amounts of cash just sitting around to be collected against when it comes to these things. And so it's kind of trying to shift that balance of risk from, who is standing to make a lot of money for doing the least and who is really putting in a lot of effort and doing the most and who is stands to gain and benefit and those things. I think the interesting thing from this, and I know I'm jumping off that reps and warranties real quick, but the audit stuff, for a lot of our clients, we're seeing that they don't care so much about audit rights in the way they did before, because the money is going directly into their wallet via the smart contract. And whether that's advisable or not to not have any kind of audit rights is one question. But there definitely is this kind of belief out in the market seeming that, well, it's on the blockchain. Why would we need to provide audit? And why would we need to incur the costs to provide accounting statements and to worry about that? You just have to give us the wallet and we're going to have it direct to the wallet. That's the end of the day. And it's when I'm on the platform side, it's a really easy argument to make. When I'm on the kind of creator side, when they're used to the create, especially music, right? A creative's life is built around audit cycles and making sure you are keeping track of what your third-party administrators are doing with your IP. It's definitely a fight about well, you don't really need it here. Well, we want it. Well, we're not going to do it. It's not building the business, and I'm not sure where that's going to wind out. I think that's one of the things that kind of seems Wild Westy in the conversations I've been having lately.
Right. It also depends on, the warranties and reps are going to be dependent on the roles and responsibilities. So if you are, not all deals, I mean, like who's administering the drop? There are some platforms, and this will apply more to the primary market as opposed to the secondary market, but if the platform, the minter, the promoter, if they're creating the NFT and they're handling marketing and they're incurring costs, then they may not want to build the splits into the smart contract, and they may want to collect 100% of the fee, and then you settle up, whether it's the end of the drop period, whether it's a, open edition or whatever it may be, or on a monthly basis. And, you calculate, you just net out the costs, and then you have to transfer the net, whether it's to the creator's wallet. Because this is new, some creators, they don't want to deal with crypto wallets. And so now you have to, wire the money to their bank account. So that affects audit rights. Yes, if the fees are built into the smart contract, there may not be any need for audit rights. But if, one of the sides is administering and then collecting and then distributing, there may be some audit rights. And then same thing with, if there is music involved, the creator, there's an artist, and there's music involved, and there may be some, they have their side deal with the label, or they have a side deal with the publisher, what the label and the publisher would get on the drop. Then, that's, when we addressed this before, I mean, that's a huge warranty and rep that, hey, that the platform needs to say, hey, look, we're paying you X, and you are responsible for all third-party payments, royalty participants. That's huge, because that is, and my guess is it's come up in some of the other panels, some of the litigation, and I know Colton can speak to the challenges of that, of some artists that don't think about that, about the other rights that are involved, and they're just, flying with these drops, and all of a sudden you get a label going, hey, wait a minute, you're using our recordings, and we never agreed to any sort of license. So once roles, responsibilities, who's doing what, that's then also going to affect the warranties and reps. So it's all kind of tied together. There's no real I don't think we can give you like a blanket list of the warranties and reps to look out for, because it's so dependent on the terms of the deal and what each side's responsible for.
Well, just real quick, on that one point before you jump in, Colton, on the point of the label or the publisher. And I'm curious what you think on this, Colton. The what this is, what this license is, or what the use is not settled, right? It's not clear that this is a sync use, or if it's and it depends on the structure of everything. I mean, there's so many different ways to look at what the use of music is in an NFT, depending on the NFT. But my biggest concern in the rep and warranty, that like I have all third-party permissions, is, well, what if I disagree with the label, right? What if the artist thinks, oh, this is a an NFT is just another kind of container for a piece of music, and so I should be paying my publisher a mechanical license as opposed to a sync license or some other kind of negotiated thing, and the publisher says, well, hell no, that's not how we're going to go about this. Well, how does that affect the rep and warranty? To the extent it doesn't have the carve out of, to the best of my knowledge, I've gotten all the rights that I think are necessary, right? I don't want that. I want to rep, you got all the rights that are necessary. So Colton's not going to come knock on my door as the platform counsel and, Joe, where's our check? I said, you got it. So
no, and you all bring up great points. And it's, I think what Kent mentioned, it's who you're, one, on the reps and warranties, who you're dealing with, right? Specifically, and I have a few reps and warranties I would like to just throw out here in a second, but I want to make sure it's clear that some of the views I express here are my views on the marketplace, and they may not necessarily be exactly BMG's views on the marketplace. But with that being said, one thing that we want, one thing that as a label or as a publisher that you would want from a platform is to ensure, try to make sure in your reps and warranties that the NFT is going to it's going to abide by and not violate like securities laws, currency laws, data privacy laws. Kind of, there's a I don't know if it's in the language that's provided in the document that was sent around, but there are certain reps and warranties that you want to ensure that you have, even if you're licensing IP. Now, to Joseph, what you were speaking of, there are times where the parties don't agree on what is actually being used, or how the IP is being used, and what rate should apply. And Is it a mechanical? Is it a sync? Is it a merchandise use? And so it's really taken on a case-by-case basis, in my opinion. We analyze what the use of our IP is, and you also have to think about the utility. What other features does the NFT give that may have nothing to do with us, right? It may be tickets to one of their live shows or something else of that matter. And you know, there's different opinions on what it is. And you know, generally it's negotiated, it's worked out. And if it's not, then you know, they'll either pull the song, which is, you know, then where's the publisher or the record label there? Now you're kind of left out of an additional revenue share. So I think it's generally in the interest of all parties to come to some form of agreement when it comes to that. I don't think there's anything set in stone right now, but I think it really is specific. You know, a lot of times you see NFTs that when you click on it that has music, it starts playing the music. A lot of times NFTs have moving images behind it. So instantly, what are you thinking? Sync rights, you know, well, one mechanical, it's stored somewhere, right? Then you have moving images. Now you're thinking sync, and then you have this kind of third tier of merchandise. And so, you know, you kind of start generally at a starting point. And I want to real quickly touch back on the audit rights, because, you know, a lot of times what we're seeing are high costs for startup, right? You know, you have to go and hire an artist. You have to go hire a dev team. They want to put, you know, either the artist or the third party wants to put money in marketing. You know, generally speaking, kind of like what Kent was talking about is, yeah, you can look at the blockchain to see the sales and the royalties being paid, but what about the cost? You know, what about the back end cost if you're working on, let's say, a net profit deal where costs are coming off the top, et cetera, et cetera. You want to have the rights to at least audit that and compare it. And it's good that you have the blockchain ledger to see the sales, but you want to be able to see that back end stuff as well. So.
All right, and kind of in a similar line, you know, we've talked a good amount about like particularly what reps and warranties and audit rights, but I wanted to kind of get a feel for, in the types of deals you're most likely seeing and the parties involved, what are the key terms that you often negotiate or most hotly negotiate, and what should people be thinking about or worried about as far as how these play out and how the deal eventually looks? We can either use popular examples of what, you know, think about, say, Snoop Stashbox or. Sorry?
I would love to hear like Kent and Joseph talk about it, because I'm sure that, you know, what they're seeing may differ than what, you know, what I'm seeing on my end, on what they're really wanting to negotiate, or the main points.
Joseph, you want to go first?
Sure. You know, I think the main points, when you boil it down, don't seem that different, because what you're really talking about is, okay, what IP are we, you know, identifying the IP you're talking about, and then identifying some sort of revenue split based off of exploitation of that IP, and you know, the tricky, not so tricky, but I guess the I don't even want to call it unique, but the thing to focus on with that is the primary market versus secondary market. And with, you know, things that are purely digital and purely, you know, in NFT for NFT's sake, you know, that secondary market isn't so much of a problem. I think the bigger thing that I find recently is when we're selling something that is got a physical item attached to it, whether it's a signed guitar or even, you know, a piece of merch on the secondary sale market. How do you make sure that that piece of thing is going with the NFT? And I find myself in the last week kind of really trying to draft provisions and kind of argue about key terms for that specific need. We're doing a big push for one of our estate clients right now, and there's a lot of physical goods left in the estate that would make for great collector's items. And as you're kind of looking in the NFT market, it's these you know, what you actually get for NFT matters, especially when you're trying to find your audience, which audience is actually going to pay money and buy into it. And these collectible items seem really great, seem really kind of prime for a great marketing campaign. but the parties can't agree on who's going to be responsible for making any primary seller make sure that item gets the secondary seller. And that's kind of a dispute that I spent a lot of time this week on without much success, unfortunately, because the sides just won't kind of agree. I mean, it's not that we don't have answers for them, it's just they've still all got to come to a consensus. Then besides kind of that revenue share, I mean, it's are you giving an advance or getting an advance, and are there audit rights and the kind of same stuff that falls into your regular sort of royalty advance-based deals that we see in the music industry constantly. And then beyond that, right, reps and warranties, indemnifications, and insurance coverage for E&O especially. It really doesn't at that point kind of seem to fall into these standard categories. It's not necessarily the key terms, but kind of the stuff that flushes out the key terms that make these different, right? The stuff that we're talking about, the know your customer rules and who's actually responsible for that, the securities rules, who's actually responsible for that. Those don't seem to really come up in the deal term sheets that get passed around. It's left to the guys in my role to make sure it's being talked about and figured out and how it's to be hashed out. I got a call today that was based off of a 1.5 page deal sheet. And they said, great, they don't actually want to go to long form. So can you add everything you would add in a long form into this deal term sheet? And I was like, sure. I mean, it's going to be a 9-page deal term. And, if you don't call it long form, fine. But it's the key terms themselves were the easy part. It's the rigmarole that goes in the flush out too. So.
And getting into some of those key terms, I mean, I think the services can be interesting because I've seen some deals where the platform, and we're using that as a generic sense, the minter, the promoter, the platform, they'll be responsible for creating the NFT and creating the artwork. And then we get into as I mentioned before, the administration of the drop. Other deals though, and this affects the warranties and reps. The platform really just acts solely as a distributor, that it's on the artist or the creator to mint and create the artwork and deliver that. So, you get into warranties and reps and making sure that the material that you're providing is non-infringing, or even it adds a layer of protection to the platform where the platform says, hey, it's, sort of the bong theory. Hey, we're not responsible for the content. We're just providing the pipes. And then so that's something that's negotiated. Or maybe it's not negotiated, but it's something to think about. It may be pretty evident who's doing what, but that's sometimes, a back and forth. And then when you get into the administration, I brought that up before, who's going to be responsible for collecting and who's going to be responsible for distributing the currency, and not only the currency, but the redeemables, the physical stuff. I call them redeemables, whether it's VIP tickets. That's something that I found lately. The question of administration it comes up. The creator is going to want to get, most people would want to get paid directly via smart contract. That is very clean. Some actually don't, as I mentioned before, it's so new that some artists, they're like, and I'm guessing on the label side too, if there's a deal where you build in the splits to the artist, to the label, to the publisher, if there's another third party participant, some labels, they just don't, as a matter of corporate policy, they don't want to deal with cryptocurrency and they don't want to deal with wallets. So I'm finding that administration, who's taking responsibility of what, is something that comes up. And again, it's not, I don't know if it's something that's negotiated, but it's something that needs to be thought about and then decided. And then you get into the fees, which really, isn't something that there's a small window. It's not like you negotiate these fees. The platform takes, I've seen anywhere from 5 to 15%. It's not like you're getting into 50% and something that's highly negotiated. So and then when you get into the secondary sales, that fee, you know, the holder obviously gets the majority of that revenue from the sale on the secondary market, and then the fee that is split or collected by the platform and the creator, you know, that's dropped down, you know, I would say generally speaking, maybe cut down in half. But that's kind of that's the market. So those are, I think, topics and issues to consider and talk about. I'm not sure how much they're negotiated. There's not a lot of negotiation, but those are important topics to address and to think about.
One thing I add to that is there was a question in the question and answer box about this in terms of, you know, we're lawyers, we're not necessarily coders. And this is one instance where there's this other thing, the smart contract that's involved, and you know, whether or not we're able to actually read that and review that. And you know, I'm certainly not going to say I'm equipped to review, you know, the coding of a smart contract, but I'm equipped to hire, you know, or to make sure the clients are hiring the right experts to do it. And in terms of reps and warranties, they're different. I've seen a lot lately that I was speaking about earlier, but a lot of reps and warranties that you have the proper skill and required expertise to properly code a smart contract or properly, you know, ensure that these things are in the smart contract. It'll be interesting to see how that gets litigated at some point, because it will. But for right now, at least, kind of making the other side, you know, like you said, Kent, it's not much about negotiation. It's kind of like these ideas have to come up, and someone's got to take responsibility for it. And you know, you might negotiate who's going to take responsibility for it, but just making sure somebody is agreeing to do it, even if you don't get into the nuts and bolts of what it is. I think can be very important in these newer spaces too. Web3 and the metaverse and all of it together. You know, it's when we're dealing with stuff that aren't the, you know, we barely knew the ones and zeros for streaming, let alone the ones and zeros for this kind of stuff.
That's a good point. Well, those are both great points from both of y'all. You know, from my point of view, or if your client is, you know, owner or license, you know, has rights to the music, whether you're a publisher or a record label, a lot of times, that stuff is flushed out, and they're just coming to you to seek the license. And so you're absolutely negotiating the rate that you're going to get. And you know, you should always seek MFN, right? Especially if you're not getting a rate that you like. And there's always communication going back with your client, with your artist, with your songwriter. You know, a lot of times we're seeing that, you know, the artist or the songwriter just wants to be involved. Don't kill this deal for me, please. Yeah. But you know, rates are an absolute huge thing. This is a new concept. I mean, it's a new concept, kinda. I mean, this stuff's been around. This isn't like a brand new, like, a license is a license. We've been doing this for years and years and years. But you know, what you're doing is setting precedent. And so if you're setting precedent at the early stages of this kind of quote unquote new technology, you want to make sure that you're doing as best as you can, because it's going to affect going down the road. And I don't see NFTs necessarily going away. I think they may evolve into something, but you know, I think this technology is going to stick around. So absolutely negotiating the rates, requesting MFN, the manner of payment. When will you get paid? If your client does not want to accept cryptocurrencies for whatever reason, making sure they're getting paid in USD, making sure they're getting paid monthly, quarterly, semi-annually. Monthly and semi-annually may not be realistic for a lot of these companies. They don't have a staff of accountants to do that. You know, who's paying conversion fees if you are converting to USD or fiat? You know, those are kind of the big things. And the other big thing is, what rights are you granting? What rights are you granting to this platform, to this third party, and how expansive are those rights? Are they limited to the NFT? Are you giving them rights to go promote it, use the sound recording or the album artwork elsewhere? So it's not really on the right scene. It's not really a negotiation, but it's understanding what your client is giving up or allowing this third party to do with their IP. And you know, Sometimes you may want to limit that. Sometimes you may want to expand it, depending on how much marketing they're putting into it, how big this is, how big how big your client is. There's a lot of things to think about when you're licensing your IP in this space, but those are kind of the majority, the bigger ticket items that we would be negotiating.
I hate to jump on real quick because you brought up something really important, the timing of the payment, because we're dealing with different currencies and exchanges, and if payment isn't made, and sometimes it's not necessarily immediate too, like the date of the purchase of the NFT and the transfer of the currency is not necessarily instantaneous. But when you get, when someone is administering, when someone is collecting and they're holding, usually at that point, they're holding some form of cryptocurrency. The platform, whoever is receiving the currency from the purchaser of the NFT, and then, that's something that's negotiated. If you're then on the receiving end, at what point, you probably want to receive the transfer from the platform wallet to the artist wallet as quickly as possible, so then you can, in a sense, play the conversion. If you are the platform and you're receiving it, it's a question of, do you want to hold on to it? You could, because if it's in your bank, you may make money on it, and the way that, the exchanges, I mean, it fluctuates on a not only a day-to-day basis, but potentially an hour-to-hour basis. So that's something, really, really important to think about is, and it relates back to who is administering, but that date of distribution of the currency. And then also gets into warranties and reps. That, hey, if you're the platform, I'm not making any warranty and representation regarding the market value of the NFT, or the conversion rates, or the loss of money due to the change in the conversion rates, the exchange rates. So all that's tied together, kind of a domino effect.
And then the other side of the warranty reps that come from the platform end too is not only do I not guarantee anything related to money, but I don't even guarantee that whatever we're going to be releasing can go into somebody's wallet. I have no say so over or control over where anything is going, where anything is going to end up, where where the rest of us claim all those warranties, all those liabilities, and good luck. And it's kind of like the first time I read that, I was like, so the platform is promising to do nothing but take its earning of the money before anything else happens. Okay, sounds like a good job for the platform.
Great points all around. Would like to remind the audience that we'll be doing like the last 10-15 minutes to doing a Q&A. So we're not ignoring you, we're just saving the questions till the end. To touch on to get farther into what we touched on briefly was secondary sales. What are the arguments for and against that being the same or less or more than the initial sale percentage? And it also kind of ties into how different parties, say labels, for example, are looking at NFTs in general and secondary sales in light of the existing IP contracts in place. So I'll throw that to whoever wants to take it first.
I mean, I'll just speak briefly on it. If the royalty rate on the initial sale just needs to be prorated down. I mean, so if, I know they're only getting 10% or 7% of the secondary royalty, but your royalty shouldn't change. It's going to be way less, but it should be prorated to your applicable rate for the initial sale. That's my opinion. Kent and Joseph may disagree, but that's the position we're taking, or that I would take as a record label or a publisher, just because it keeps it the same.
Well, I think the rate decreases for a couple of reasons. I think I'll say the most important is knowing the market, knowing the crypto market and the blockchain, and at least the advice and the information that I got is that when you're dealing with these investors that are purchasing NFTs, the audience is there. To me, there's two kind of sets. There's two groups that make up the audience. One is just the crypto investors. All right, they don't really care what the NFT represents. You know, they want to make sure there's value. I'm sure they're doing some research, but it's an investment. And the other side is the fan. You know, whether it's the fan of the artist, the fan of the artwork. So you need to understand that. And if you're a crypto investor and you're buying this NFT and you're looking to resell it, if you know, you can, you know, everything's transparent, you can read on the smart contract that, okay, BMG is taking this huge percentage of I'm the holder, I'm reselling it, and they're taking a huge chunk. Or whether it's the artist or the platform, if those percentages are high enough, it's going to be act as more of a, it's going to be more prohibitive, you know, where you're not going to, the investors are not going to be interested because they're not going to be making as much on the secondary market. So I think that's one reason why the percentages drop down, because you need to be considerate of the whole community and the investors. The other is that, you know, you just look at the value and the service. You know, once the NFT is out there, once it's sold, you know, what value does, say, the label or the publisher really have in that secondary sale? Or what service is the platform really providing? Any additional service on that secondary sale? The NFT is out there. It you know, lives in the blockchain, and then someone's reselling it. So I think there's legitimate reasons why those percentages would come down. And also, it's just, look, I think it's just great that there is a percentage. You know, if I buy an album and I go to the store and I, you know, want to sell my album, the artist doesn't get paid on that. You know, it gets in the first sale doctrine. Here, you know, whether it's a ticket, whether it's music, whether it's whatever it may be that is, you know, that the NFT is giving access to, you know, that resale, the artist, the creator still gets paid. So, you know, maybe I'm rationalizing a bit, but I think those are all fair things, at least in defense of reducing the percentages on the secondary sale.
Yeah, no, I agree 100% with you. The NFT market, the consumer market absolutely looks at the royalties for secondary sales. And so it does make sense. I guess what my point is that, you know, you should think about basing your royalty percentage on what is actually being received. So if on the initial sale, it's 20% of a dollar, it's 20% of a dollar, but just know on secondary sales, if they're, you know, only getting 10%, then it's 20% of 10 cents. So it's maybe not prorated, it's prorate, it's, you know, the understanding that it's going to be much less, but it's still the same percentage. It just makes it easier. And then two, you know, this is also something to consider. Your initial sell is generally going to have fees associated with it from the platform, but secondary sales, generally the fees are already taken out. So you need to understand that should be really based off gross received and not really a net.
Yeah, and that's why there's a difference in the calculation on the primary sale versus the secondary sale. But I'll just for sake of fun conversation, you know, when we talk about the value in the NFT and the value of a sale in the secondary market, if there's a package where maybe there's artwork and there's some music attached to it, and I'm representing the artist here, and I've negotiated I'm negotiating a deal with the label or the publisher in order to use that music as part of this loop or part of this added part of, you buy a ticket and you get, this song. When that's sold on the secondary market, and let's say, it's purchased for, this great experience for $1,000, and then it just increases in value. It's so, it's unique. It's a collectible. Only 100 people on the planet have this, and you sell it for $100,000 on the secondary market. I'm sorry, but the label and the publisher, it's not about that. People aren't buying it. I don't think the value is, the value is with the artist and the experience. So for the label or the publisher to be getting a percentage of the $100,000 to me is completely disproportionate. Now that's going to get into, like, Colton, if we're negotiating a deal for an artist to drop an NFT that has music, we're going to negotiate at that point in time. But I'm still kind of tying that into why that percentage on the secondary sales should be dropped down.
Well, and these are fantastic arguments and what you would be expecting to hear. So all those attorneys out there, these are what you're going to have to negotiate with. These are the kind of conversations you're going to have, and you're going to have to craft your negotiating to either address what Ken said, or to understand it. And that's, but Ken, you make a good point. But yeah, those are certainly negotiation points for sure. But generally, and I just want to make sure this is clear though, generally, it's not contentious where we're just knocking heads. Generally speaking, it's something that it's another revenue stream that one is, as we've seen, have been, it's been blowing up. So I think it's working together to figure out the best terms, and not a bunch of knocking heads, even though I'm sure there's plenty of knocking heads to go around.
Yeah, sure. That's coming from one of the more forward-thinking, progressive label publisher attorneys out there. I think Joseph and I could speak, dealing with other, some of the bigger corporate labels are not as open-minded. They are still greedy and controlling and don't get it. Not only, do they not get the market and how the market works, but, they just think that, their IP is worth more than anything else, and they don't want to, not necessarily give it away, but it's much more difficult trying to explain this whole market and world to those other more, I don't know what the right word is, stubborn labels, business affairs attorneys at these major labels. So compliment to you, Colton.
Yeah, I see more so, and I'd like to do more deals with you, Colton, I guess. But I see more so that the BAs I've been dealing with, they just came out of figuring out how to make money in the streaming economy, and now they're making it hand over fist, and they don't want to see a new mode of consumption of material come where they feel a 2000 or 2010 dip in revenue all over again, right? It's oh god, if the NFT market's going to become the new Napster or the new iTunes, and we're not going to make any money on this if we don't get in first this time. It kind of feels like almost a reaction to what happened before, and how it took a while to figure that out to now being, well, we're gonna make sure we're locked down real quick on this. And what I keep seeing is those who will open up their mind and kind of understand where this is going and how this is different and work with us from the artist side, or even from the platform side when we're doing kind of bigger catalog type deals for platform clients, the benefit is just great. Not only is it great in terms of the financial rewards we'll be seeing, and sure, the big splashy deals are making all the money, but it's kind of really the upper middle class deals that keep people in really invested in this. There's money to be made there, but there's also a new relationship to build between the artist and their label. We've got a world where so many artists think their labels do nothing for them anymore, especially since they've shed label services like crazy over the last decade or so or more. And now it's like, okay, if we're going to work with you on a campaign here to build up not only kind of fan engagement, whether it's kind of through like fan club type activities, but make the build into the Web3 and get you a house that's Snoop in the sandbox. It becomes much more interesting for these artists who want to be on the cutting edge, want to be doing what is theoretically cool. So it's better for us all to kind of go, okay, great, this is happening, it's here. How do we make it work together rather than, okay, it's happening, it's here, where's my piece?
Yeah, I think the platforms are running with it. I mean, a lot of the, I try to avoid, the artists that have labels and publishers, because it is just challenging, and it works so great with the artist, whether it's a young independent artist or a well-established legacy artist that is out of their deal, and whether they can re-record songs, use live recordings, things like that, where the platforms are really just I think some of the bigger platforms I know a lot of the gaming platforms are so hungry and love the idea of disrupting the music industry, and they're saying, hey, fuck labels, this is your new label, the blockchain is your new distribution platform for all the reasons that we've talked about, and I'm sure all the reasons that people have talked about all week with these panels, but they love running with exactly what you were saying, that this is the new label of Web3 and of the 22nd century or whatever, and I believe it for the right artist, or the right creator, if there's real value in the NFT. And then I know this isn't for this platform, but where this is all going, it's not just NFTs, but then we get into node networks and things like that, where that will really change, I think, really change and disrupt the industry, but that's for another panel.
And on that note, as loath as I am to cut off this conversation, I think we should turn to some questions. I wanted to touch on securities a little bit, but seeing as Beverly Hills Bar just did a great securities panel around NFTs, I'll just reference that. I believe it should be available on a recorded format relatively soon. Contact the Beverly Hills Bar for that. So let's start going into a few of the questions. There's a lot of them. Sorry, I can't get to all of them. So I'm just going to kind of randomly select a few of them. Let's see, a simple one. Are there any terms restricting on which marketplaces secondary sales can be carried out? So I want to take, is that more of a tech question?
What was the question?
Do you negotiate terms restricting which marketplaces the secondary sales can take place on?
That doesn't really happen anymore. I mean, I think back in the day, which maybe the day being 6 months ago, I think there were platforms that actually restricted this. I think it was maybe OpenSea. Like if you purchased an NFT on OpenSea, you could only sell it on the OpenSea market, but that has pretty much gone away, and you can NFTs can be wrapped, and so you can actually move. You can move your wallets. You can move your NFTs to different platforms, different currencies, things like that. So I really don't think that's an issue anymore. And as the minter of the NFT, I don't know why you'd want to control, where it's sold and resold.
In fact, when we were doing, still when I'm doing deals on the platform side, we'll oftentimes get a comment about, we want to make sure that you're going to account to us for all secondary sales, whether they take place on this platform or not. And the response is, we have no way of controlling that. If you can move the NFT off the platform and sell it somewhere else, we can't, yes, it's the blockchain within a blockchain is trackable, but if you can get it moved somewhere else, there's no way for us to follow that. And so we're basically disclaiming, again, from the platform side, we're disclaiming the ability to collect all fees from any secondary sale, just because there might be secondary sales we never know about, especially when you're talking about the more, NFTs that go along with some sort of physical object. I go sell I buy a guitar signed by, one of Kent's clients, and go sell it to a pawn shop, right? That secondary sale to the pawn shop is not going to get reported on the blockchain. I tell you what.
Okay, next question. I think we touched on Know Your Client a little bit, but here's one specifically related to that. Do artists who are minting and selling NFTs have an obligation to know and report the customers who are buying NFTs under Know Your Client laws?
I won't speak too specifically on this because I haven't done the research. I've got a great colleague in our New York office who I just is my go-to when it comes to this issue. But what I understand from him is that anybody who is receiving revenue from the sale can be held liable for a violation of the KYC rules, right? If your NFT ends up getting sold to somebody in North Korea and you make money off of it, as a recipient of that money, you have some liability in the chain. I haven't seen that go anywhere or anybody try and have anything enforced against them or whatnot, but I do know that there's a lot of platforms who are trying to push the fact that they handle the KYC for everybody as a reason why you want to use that platform versus another platform.
Thank you. Interesting one is, have any of you come across any equivalent or analog to E&O insurance in the myriad of IP litigation that might come up with NFT sales? And how does, the question is roughly what does it cost? But I'm curious, like, how would that even work if you've even seen something like that?
My understanding is it's expensive. And we're again, kind of coming from the platform side or organizer side or kind of the middleman side. We always want to have, the artist or the creator tell us they've got an insurance policy that covers any sort of infringement claims that might come from any other third party, or if I'm doing a deal with a music artist and that music artist is responsible for getting the artwork, right? I want there to be some sort of policy that's going to cover any claims from that artist or anything, any third party in that way. Most of them have told me to go beep myself when it comes to that, because again, it's just too expensive, and the time to get that policy is takes forever. So we have some clients on the platform side who have their own policies and who will insure third parties under those policies just to make sure there's some coverage. But it's definitely something we want constantly and are not getting.
And it depends on what the package is. I'm not sure if we're when maybe if a label becomes much more involved and a label has their own marketplace and the label is providing recordings, but here we're dealing with, for the most part, artists that are creating and dropping these NFTs that do give access to something on the other side. But do you need insurance on a ticket? Do you need insurance on a VIP experience? Do you need insurance on you've got, if you're hiring someone to create some great digital artwork and you've got your work for hire, most people aren't getting E&O insurance for that. So I think there's much maybe like the insurance world in general, whether it's auto or health insurance. I mean, everyone's taking a risk, but I think the reality here is until we get into much bigger drops and different types of platforms, node networks, things like that, I just don't really think it's a reality or applicable just yet.
Yeah, great point. Okay, last question. Sorry, everyone else, that we can get to yours. We touched on it briefly, and there's a few questions in the chat about how do you address the smart contracts in the legal written contract. Kind of ties into how much tech a lawyer really needs to know to be negotiating these, and what recourse do you really have if the smart contract isn't right?
Well, I can talk about what's come up and it specific to the fractionalized interest and things that like Royal is doing, where you need at that point, I mentioned it before, a purchaser agreement that the purchaser who's buys the NFT, which gives them the access, the right to a percentage of a royalty income stream. There's a written contract between the purchaser and the artist, the artist that is receiving the royalty, and they're saying, hey, you, the purchaser, you now get whatever it is, 10% of that. So there has to be that separate agreement. And also in that is all the warranties and reps. You get into all the securities and the disclosures. From what I'm told, I haven't dug into this yet, but I'm in the process right now of, representing a platform that is doing that. And I'm being told from the tech people that that agreement will actually be burned or encoded or embedded in the smart contract. And then what you have is, I accept, it's a click. So it's not anything that you can, as the purchaser, you can't negotiate it. It's just click to accept. And then it becomes a question of the timing, because do you have to buy the NFT to then be able to have the smart contract information, or do you have to accept the terms of the agreement before you buy the NFT? Also, what we've done is you put the agreement on the platform itself. And if you want to enter the platform, or if you want to get into the particular market where these NFTs are being held, that's where you have to click to accept the terms of the agreement to enter in. So Joseph, I'd be curious on your end whether you prefer to have those agreements on the front end, or if those agreements actually will be encoded in the smart contract, because what you have is there's the initial purchaser, right? And so when they go in and they want to buy something, you can click to get into the marketplace. But what about on the secondary? There's no one's on the particular the marketplace. They're buying it on the secondary market. The only way for them to accept the terms of the agreement is by purchasing the NFT. You're accepting the terms in the smart contract.
Yeah, my preference, and I'll try to do this as quickly as possible. Right, my preference is that the platform has a terms and conditions that require, adherence to any terms and conditions that are applicable to any specific NFT. Hopefully, those terms and conditions for that specific NFT, which is where you get into what you can do with the music or the art that's in any given NFT, is something available on the kind of auction or sales site as its own kind of terms of use, or that is, it has to be in a smart. Again, the smart contract isn't, at least the way I conceive of it, it's not exactly like a contract with terms and conditions. It's if then statements or if then conditions, right? So you Colton and I agree that anybody who owns this NFT has the right to make a remix of the piece of music they've got, but they can't upload or they can't register new publishing splits in that remix, right? It's got to go to the same original writers. Well, there's not going to be a clause in the smart contract that anyone can go to look to say that, but the smart contract is going to be coded in a way that allows for, certain things, or that will then have a final kind of block in it. And this is what I kind of like when you're talking about burnt into it, Kent, is my understanding, is there can be big chunks of text kind of within the smart contract that are not functional code, but that if you do open up and see what the code is, you would see, these terms. So I like to have it in there as well. But my kind of main thrust is just to get those terms in front of the buyers as soon as possible, as clear and transparent as possible, so that they understand if they read them, which they're never going to do anyway. But if they do read them, to say like, oh, I'm not actually owning this piece of music that I'm buying. I can't go resell it. I can resell the NFT that contains the music, but I can't separate the music out and go license it to a movie or do anything else with it that I think I might have the rights to. And I think that we're
notify the purchaser on the secondary market, though. You just have to tie them to, hey, you need to go to this original source.
Yeah, I mean, I think, and that's the case why it has to be in that smart contract as well, because you've got to have it someplace that's going to make sure it goes with it. But it's just really just a text file attached to a smart contract, or a smart contract that has something in it that allows you to access a text file that goes with it. But again, I think I probably run the same problem they do with Nictaro over there. So anyway, I said I'd make it quick, and I definitely didn't.
Again, awesome conversation. Hate to cut it off. If anyone has any quick closing comments, please make those. Otherwise, it's been an absolute joy. Thank you all for your time. I really appreciate it. Yeah. Thanks audience for joining us. Sorry.
I was going to say thanks everyone, and whoever was actually on this, they were missing the one-on-one conversation with Sarah Buxton and Snoop Dogg about the stash box. So, I wish I was listening to that one, but this was quite entertaining, and I appreciate everyone's time as well.
Agreed.
Thanks, everybody.